Welcome, everyone, to the Ontario Caregiver Organization's webinar series. These webinars bring together caregivers and subject matter experts to explore topics of interest to caregivers. We do this to support and engage chosen family, friends, and neighbors, really anyone who's caring for someone else. My name is Katie Muirhead, and I'm going to be your moderator for today. We begin this gathering by acknowledging the Indigenous peoples of all the lands that we're on today. And while we meet on a virtual platform with people joining us from across the province, I'd like to take a moment to acknowledge the importance of the land we each call home. The land I'm standing on is the traditional territory of the Haudenosaunee and Anishinaabe peoples, many of whom continue to live and work here today. This territory is covered by the Upper Canada Treaties and is within the land protected by the Dish with One Spoon Wampum Agreement. Today, this gathering place is home to many First Nations, Métis, and Inuit peoples, and acknowledging this reminds us that our great standard of living is directly related to the resources and friendships of Indigenous peoples. As team members at OCO, we are learning about the lands from which we work, exploring how we can be meaningful allies and how we can support the recommendations from the Truth and Reconciliation Commission. We do this to reaffirm our commitment and responsibility in improving relationships between nations and to improving our understanding of local Indigenous peoples and their cultures. We invite you to take a moment to reflect on the land where you are. And if you're not familiar with that, we'll be sharing an interactive map that tells you which traditional territory your city or town sits on. And you can find that at native-land.ca. Laws and rules are complex and may be difficult for caregivers to understand. Yet having the right legal information can help everyone feel informed and empowered to support the best patient care. Today, we're going to learn more about legal topics, including substitute decision-making for property and personal care, healthcare consent and advanced care planning, and some general information on Henson trusts and wills. And I'm very excited to introduce our speaker today. Today, we have Graham Webb joining us, who is the Executive Director of the Advocacy Centre for the Elderly, or ACE. And before joining ACE in 1995, Graham was engaged in private practice in Barrie, Ontario, in general practice with emphasis on civil and criminal litigation. He has appeared in civil and criminal matters at all levels of courts and tribunals, including the Supreme Court of Canada. Graham gives periodic legal education presentations on elder law issues to older adults and service providers, including healthcare professionals and other lawyers. Welcome, Graham. We're so happy to have you join us today.
Thank you, Katie. Well, thank you everyone for being here, and it's our real pleasure to present on understanding healthcare laws and rules. I'm coming to you today from Toronto, at the offices of the Advocacy Centre for the Elderly. We are a specialty legal aid clinic. We're funded by Legal Aid Ontario. We provide legal advice and representation to low-income seniors, and we don't charge fees for service. We do a lot of work in this area of law, and I'd like to unbundle the healthcare consent laws and rules within the short time that we have. The things I'm about to tell you are not at all legal advice. It's general legal information. Anyone is free to call our office for general legal information and or summary legal advice if you're an older adult whose rights are an issue. We also provide general legal information to anyone who calls or referrals. When we're thinking about substitute decision-making, the first thing we really need to turn our minds to is the mental capacity of the person whose rights are an issue. And, capacity is not a one-size-fits-all matter. There are different tests of capacity under Ontario law for things like making your own property decisions, for making your own personal care decisions or your treatment decisions. Yet a different test of capacity for giving or revoking a power of attorney for property, and for giving or revoking a power of attorney for personal care. And so a person could be, for example, mentally capable of changing their power of attorney for property, but not mentally capable of making their own property decisions. Or a person could be mentally incapable of making their own personal care or treatment decisions, but still have enough residual mental capacity to give or revoke the power of attorney for personal care. So when we're speaking of mental capacity, it's not one size fits all because it depends on what type of decision is being made. No matter uh, what type of capacity we're talking about, the individual legal definitions generally revolve around two ideas. The first idea is that to be mentally capable, a person must be able to understand information that's relevant to making a decision, whether it's a financial decision or a treatment decision or any other type of decision. The second general element is a judgmental component, which is the ability to appreciate the reasonably foreseeable consequences of making or not making a decision. So, sometimes we meet older adults, for example, who may have a very good knowledge of the factual matters, but for one reason or another are simply unable to appreciate that if they give a power of attorney for personal care, that the person they name in the power of attorney document may actually have to make decisions on their behalf that they might not agree with. And in that case, the person would not be able to appreciate the reasonably foreseeable consequences of giving the power of attorney, and they would be mentally incapable of making the power of attorney. And the same idea flows through for other elements of decision making. And so it would be really easy for family members and service providers if we could have that one size fits all description. If somebody asks, is your mother or is your loved one mentally capable, to say yes or no for all purposes, for all times? But that's not the way it works because capacity changes from decision to decision and from time to time. So at one single point in time, a person might be mentally capable of deciding one type of treatment decision, for instance, whether they want to have cataract surgery, but not mentally capable of another type of decision as to say whether they should or should not be taking a certain type of medication. And that could be at the same time. Also a person may have a medical event. Someone might have a urinary tract infection, which can cause a loss of capacity on a temporary basis. And when the infection is treated, the loss of capacity lifts, and the person would regain mental capacity within a fairly short period of time. So when we're thinking of capacity, we're thinking of capacity for what purpose, for what decision, and when, because it's always changing. Now, if a person is mentally capable of their own decisions, then they are their own decision maker. But if a person should lose mental capacity, then there may be a substitute decision maker who could make decisions on behalf of the mentally incapable person. And that's what I'd like to begin to unwrap now as to how that substitute decision-making process works. The first thing that everyone should know is that anyone who is physically present in Ontario, if that person should lose mental capacity for a treatment decision, it could be, an emergency medical treatment for a heart attack or for something following a car accident, or it could be a long-term condition, could be something arising from dementia, or it could be anything, but a loss of mental capacity for a particular treatment decision. Then there will always be a substitute decision maker. You don't need to have a power of attorney uh, because there's a list of the substitute decision makers under the Healthcare Consent Act. And what's in front of you right now is that list. The way it works is we start at the top and we work our way down to the bottom until we find the decision maker who has substitute decision making authority. The highest on the list is a court appointed guardian with authority to make the decision. There are not many people who have a court appointed guardian. We'll speak again about this, but there are two types of guardians, property and personal care. And here we're speaking of someone who has been appointed by an order of the Ontario Superior Court of Justice to become the incapable person's guardian of the person with authority to make treatment decisions. And when the court makes a guardianship order, it can be a full guardianship or partial guardianship. It can either give specific powers or exclude specific powers. It may be guardianship over some aspects of personal care decision making. And it's important, if there is a court appointed guardian, that the guardianship order actually include the authority to make personal care decisions. And there are actually very few of those court appointed guardians in Ontario. What's much more common, and what is number 2 on the list, is a person holding a power of attorney for personal care on behalf of the incapable person with authority to make the decision. And as we'll mention later again, if someone gives a power of attorney for personal care, which we'll unpack, the power of attorney may have conditions and restrictions. Most powers of attorney are unconditional and unrestricted, meaning they have no conditions and no restrictions, which would automatically give the person named as the attorney for personal care the authority to make personal care decisions, which include treatment decisions. And there are a great many of powers of attorney for personal care without conditions or restrictions that are authorized the attorney for personal care to be the treatment decision maker. These are very powerful documents. If there is no power of attorney for personal care in place, then someone may apply to a tribunal called the Consent and Capacity Board to be appointed as the incapable person's board appointed representative for the purpose of making a particular decision or category of decisions. This is not a difficult process. You don't need to have a lawyer, and there's no cost to it, and it's a fairly short process too. If there's none of the above, then the next category of decision maker would be a person's spouse or partner. The next would be a parent or child. The next after that would be an access only parent of a child, because within the definition of parent, if the parent is a parent of a child and only has a right of access, then that's excluded from parent. And we're speaking of a parent, an access only parent, is a lower category. After that is brother or sister. After that is any other relative by blood, marriage, or adoption. And this covers a very wide net. And finally, if there is none of the above, then the default would be the treatment decisions unit of the public guardian and trustee. And so you see that whether you do or don't have a power of attorney in place, there will be a substitute decision maker should anyone become mentally incapable of making their own treatment decision. It doesn't matter how someone gains decision-making authority for being a substitute treatment decision maker. They have to follow the same rules, whether they're appointed by the court, whether they're an attorney for personal care, whether they're a spouse or partner or brother or sister or relative, or even the public guardian trustee. The same rules apply to everyone. The first rule for substitute decision makers on treatment decisions is to follow the last capable wish the incapable person made that would apply in the circumstance. And if, and only if, there is no last capable wish that would apply in the circumstance, then the substitute treatment decision maker must act in the person's best interests, which has its own definition. A lot of people really get this mixed up, you know, when they're called on to make a decision, their first thought is, what is in my loved one's best interest? And that's what the decision maker will naturally want to do. It's the thing we want to do for people we care about. But in law, our first duty is to think about what is the person's last capable wish that would apply in the circumstance. And here, um, written wishes and oral wishes have the same weight. It doesn't matter if the wish was written down. It doesn't matter if it was expressed in a document commonly known as a living will or some other document. It just matters, oral wishes and written wishes and every other form of expression have equal weight. The most important rule is that later capable wishes take precedence over earlier capable wishes. So a person might go to their lawyer and ask the lawyer to create a document called a living will, writing down what their last capable wishes are, and pay for it and get it all signed, sealed, and delivered. And the next day, they might say to their substitute decision maker, you know, that living will I got, I've changed my mind. If I have this type of medical event, let's say my heart stops, I now want you to start it up, even though the living will says something different. And so what that oral wish would do, if it's capable, would completely cancel the earlier written wish. So later wishes take precedence over earlier wishes. And when we're thinking of advanced care planning, the two things we're thinking of most importantly is knowing who on that hierarchy, who on that list would be your substitute decision maker. If you have a power of attorney for personal care, who is that? If you don't have a power of attorney for personal care in place, would it be your spouse or partner, your parent or child, your brother or sister, your other relatives, knowing who it is? And secondly, having regular communication with that person so that person would be well informed as to what your last capable wishes are. When you give an advance directive or a living will, that doesn't speak to the doctors. It's not intended for the persons who are providing healthcare to you. It's intended to give instruction to the person who will be making the decisions on your behalf. Because if a physician or any other regulated health practitioner proposes a treatment, the health practitioner is required to obtain informed consent from the person or their substitute decision maker before administering the treatment and before allowing anyone else to administer the treatment. And so the physician can't take instructions from a piece of paper called a living will or an advance directive. They have to take instructions from a person who is either the capable person giving their own, making their own treatment decision, or a substitute decision maker acting on behalf of a mentally incapable person who's mentally incapable with respect to that treatment decision at that time. And here's the thing. In order to make those decisions, the decision maker must be him or herself mentally capable. For example, sometimes here at the Advocacy Centre, we'll have cases where, say, an older adult, let's say an older an older woman is in hospital receiving urgent hospital care, temporarily or permanently mentally incapable of making her own decisions. And it's called on her husband, who's living in a community, to make substitute treatment decisions on her behalf. But in some cases, it turns out that the husband is also mentally incapable of the treatment decision. And so then it turns to someone else who's farther down the list, like the older adult children. Secondly, the decision maker must be at least 16 years of age, unless the person who is under age 16 is the parent of a child who is the subject of the treatment decision. Thirdly, the decision maker must be available. And available doesn't mean they have to be present on site. If there's an event in a hospital that requires a substitute decision maker, the decision maker doesn't have to be at the hospital or at the bedside. If they're available to speak by telephone or by video conference or some other method, then that's available. They don't even have to be present in Ontario or in Canada. They could be anywhere in the world. And in this day and age, the meaning of available casts a very wide net. And finally, the decision maker has to be willing to make a decision, because it's not a legal obligation of the decision maker to make a decision. They can choose not to decide, in which case it would fall to the next person on the list. And so as you go down this list, a lower ranked decision maker can only make a decision if a higher ranked decision maker doesn't exist, or if the higher ranked decision maker is not available or is not willing to make a decision. Now, in many categories, there can be more than one decision maker. For instance, a power of attorney for personal care might name multiple decision makers jointly, multiple attorneys, or if it falls to the children, there might be more than one child who disagree with each other. If there are multiple decision makers within a class, they all have equal decision-making authority, and it's not a majority rule. If one person, say one of the adult children, asserts decision-making authority and nobody else disagrees, that's fine. They don't all have to agree, but if there's no disagreement, then the one who's asserting decision-making authority will make the decision. If more than one assert decision-making authority and they disagree, then they're deadlocked. It doesn't matter if it's 3 against 1, and it doesn't matter who's the eldest and who's the youngest, and it doesn't matter who's the favorite or who lives the closest or who lives in British Columbia or Australia or Toronto. If they are all within the same category, if they don't agree, then they're deadlocked. And so if they're deadlocked, what happens then? Well, the Office of the Public Guardian Trustee Treatment Decisions Unit will try to mediate between the disagreeing decision makers and coach them through applying the correct principles of decision making. In other words, to follow the last capable wish that would apply in the circumstance. And if there is none, then to act in the person's best interest and to come up with a mediated decision between the disagreeing decision makers. If they can't agree, then the Office of the Public Guardian Trustee will make the substitute decision on the incapable person's behalf. I'd like to speak to you about powers of attorney. There are 2 types of powers of attorney, for property and for personal care. It doesn't matter what kind of a power of attorney it is. It must be made in writing. It must be signed by the person giving it in the presence of 2 witnesses, both present at the same time. And the witnesses must also sign the document in the presence of each other. Sometimes we see cases where a person will have their mother or father or their brother or sister sign a power of attorney, witness it, and then take it to someone else and say, here, this has been signed by my mom. Will you witness this too? outside the presence of the person who made the power of attorney. And that can't be done. It's not a legal form of power of attorney, because what it amounts to is the power of attorney must be signed in what we call solemn form. This is by operation of statute, the Substitute Decisions Act. It's because these documents are so powerful and so important. You know, there are really two other types of legal acts that are usually done in solemn form. One of them is making a will. A will doesn't necessarily have to be made in solemn form, but in most cases, the will is made in solemn form, signed by the person giving it, and signed by two witnesses, both present at the same time, who sign in the presence of each other. And like making a will, giving a power of attorney is a legal act. Another legal act that must be done in solemn form is getting married under the Marriage Act. That's how, if you want to go through a legal form of marriage, there is a register to sign, and both parties, both spouses to the marriage, sign the register in the presence of each other, and in the presence of two witnesses who both sign in the presence of each other and in the presence of the spouses. And this signifies the importance of these acts, because the power of attorney for property or personal care is a very, very powerful document. Before giving one, someone should be really aware of what they're doing. They should be knowledgeable, and they should know that getting into a power of attorney can be a lot easier than getting out of it for a lot of reasons. I think of giving a power of attorney as kind of akin to getting married. Getting married can be a wonderful thing, but getting married is not necessarily for everyone. And before someone gets married, they should make sure that they try to understand what it is they're getting into, and they should be doing freely and voluntarily. And nobody should be ever getting married because they think they have to get married. And the same is true for a power of attorney. If you're giving a power of attorney, you should, if necessary, get legal advice, but certainly understand what the power of attorney is about. You should be doing freely and voluntarily. It should be your own idea. If it's someone else's idea that you should get married, maybe it's not the best idea. If it's someone else's idea, you give a power of attorney, then maybe you should be thinking about that, because you don't have to give one. And you should never be giving a power of attorney because you think you have to give one. And really importantly, if you're getting married and you're not sure who to get married to, it would be ridiculous to get married unless you're sure of that. And so too with a power of attorney for property or personal care. If you're undecided about who you should give the power of attorney to, then it would probably be better not to give one at all, unless you're really sure that this is the person you want to give the power of attorney to. Powers of attorney for property and personal care are so different that it's kind of unfortunate they have the same name. In a power of attorney for property is known throughout the world as simply a power of attorney. The rules about that are very long established. Powers of attorney for personal care are kind of unique to Ontario. In some other jurisdictions, like New York, for example, they call it a healthcare proxy. In a power of attorney for property takes effect as soon as it's signed. And so if you give a power of attorney, the minute you sign it, you can still access your own bank accounts, but so could your attorney. It takes effect as soon as it's signed, unless you say otherwise. A power of attorney for personal care is the opposite. It becomes effective only if and when you become incapable of making your own personal care decisions, which for many people might never happen, or it might happen for a very short period towards the end of your life. While you're mentally capable, you can delegate your property decisions to your attorney for property. But while you're mentally capable, you can not delegate your personal care or treatment decisions. You are your own decision maker. If you don't have a power of attorney for property or personal care, it may be possible to appoint a guardian on your behalf. One type of guardian is a statutory guardian for property. It's only available for property, which doesn't involve going to court. It means that somebody, yourself or someone on your behalf, would arrange an assessment of your capacity to manage property for the purpose of creating a statutory guardianship under the Substitute Decisions Act. This type of assessment is a very specific type of assessment. It must be done by a designated capacity assessor who is a certain class of regulated health practitioner or a social worker who's a member of the College of Social Work, who has taken training, who has liability insurance, and who is designated by the Capacity Assessment Office of the Public Guardian and Trustee as a capacity assessor qualified to perform these assessments. It's done on a fee-for-service basis. It starts in the hundreds of dollars and goes up from there. And if the capacity assessor is requested and performs an assessment and finds that the person assessed is not mentally capable, the capacity assessor will issue a certificate of incapacity, which makes the public guardian and trustee the incapable person's guardian of property for all purposes. The public guardian and trustee has the legal authority to delegate the guardianship to a family member or a trust company who applies to do that, but the delegation is a discretionary power that can also be revoked by the PGT if there are reasons to do so. Another form of guardianship is a court-appointed guardianship, where someone applies to the Superior Court of Justice for a finding that a person is mentally incapable of either property or personal care decision-making or both, for a finding that the person needs a guardian, and an order appointing a specific guardian or guardians of property and of the person. This is a less common step, particularly for personal care. It's very intrusive, and it's expensive, and you would usually need to have a lawyer help you with this. I'd like to turn to the issue of Henson trusts, which is a very popular topic for persons, well, caring for persons with disabilities. Henson trusts relate to the rules around the Ontario Disability Support Program. This is a social assistance program that is means tested. And under the ODSP rules, a person who has too much income or too many assets will no longer qualify for ODSP. There is an inheritance trust. So if a person with disabilities is on ODSP and receives an inheritance or the proceeds of a life insurance policy of up to $100,000, that inheritance or proceeds of up to $100,000 can be held in trust for the ODSP recipient, and it won't affect their entitlement to ODSP. Now, in other cases, a Henson trust can be created. It has no limit. A Henson trust is what's really known as an absolute discretionary trust, where money, and it could be any amount of money beyond $100,000, is placed in trust with a trustee who has a absolute discretion to make or not make payments to the recipient of ODSP. So there's no legal right of the ODSP recipient to receive anything at all from the trust. But creating this trust will not affect the rights of the ODSP recipient to continue receiving ODSP. Now, under rules that have been recently amended, an ODSP recipient can have up to $40,000 in assets without affecting their entitlement. And under rules that have been long-standing, the ODSP recipient can receive gifts of up to $10,000 per year without affecting their entitlement to ODSP. And so For example, if $500,000 were placed into an absolute discretionary trust with power to make gifts to the ODSP recipient, and from that $500,000 trust body, $10,000 per year were paid out to the ODSP recipient, that could happen for for as long as the person is otherwise qualified to ODSP without affecting their right to continue receiving ODSP. If it happened outside the trust, it'd be a little bit different. And finally, Henson trusts are very popular because uh, if the ODSP recipient were to die or to no longer become entitled to ODSP, the money left in the trust we call the residue could be transferred to other persons within the same family unit or other beneficiaries like brothers and sisters of the recipient. So it's a very useful estate planning tool. Finally, about wills and estates, uh, we at the Advocacy Centre, we don't usually prepare wills, and neither do we um, administer them because, we act for the older adult whose rights are an issue. We don't act for the estate, and we don't act after the person is deceased. But we do handle many questions about wills, what they do. And one of the most common questions we get is when an older adult has passed away, someone who's very distressed, a loved one, will call in and they'll ask us about saying, I hold the power of attorney for my mother. She just passed away. What do I need to do under the power of attorney? And the answer is nothing, because a power of attorney is terminated when the person who gave it passes away. So it ends when with the life of the person who gave the power of attorney. It only operates during your lifetime. And conversely, a will only takes effect when a person passes away. It's only effective after the death of the person who gave the will. So the will and the power of attorney can never operate at the same time unless you could be alive and dead at the same time. It's one or the other. And in very general terms, the purpose of a will is first of all to name a person, either called an executor or executrix or an estate trustee, who will be the personal representative of the deceased person after they pass on. And the personal representative, the executor or the estate trustee, will usually be responsible for um, carrying out the funeral arrangements, whether it's a cremation or a burial or whatever interment is required, for paying the deceased person's just debts, their funeral and their testamentary expenses, and to distribute the person's estate according to the directions given in the will. And the other purpose of the will is to give directions as to how the person's property should be distributed after their death. There are different ways of making a will. Normally, if a person owns real estate or has substantial savings, it'd be really important to get legal advice on making a will to make sure there's no disputes after the person is deceased as to how their estate should be distributed. Finally, the person named as the executor or the trustee will normally be paid compensation as a percentage of the estate from the estate assets. Though here's contact information. We'll be giving you more referrals and so on. But this is the information I wish to share at the moment, and I'm pleased to answer any questions you might have.
Thank you so much, Graham. That was a tremendous amount of information in a very short amount of time. You did fabulously in providing that in a really clear way to folks. So I want to thank you so much. Now is the time for questions, folks. So if you do have questions for Graham, please throw those into the chat box, and we're going to spend about 15 minutes or so going through some of them. we've had a couple come in so far, and I'm just gonna look at my handy dandy phone here to review those. So the first question that came in, and just as maybe a refresher, because we did just go through a lot of information, can you just clarify the difference between a power of attorney for personal care and a substitute decision maker?
They're the same thing. A substitute decision maker is more broad. It could apply to someone who's making substitute decisions for an incapable person in respect of property or in relation to personal care issues, including treatment. Um, the power of attorney is actually a document. It names a person who is the attorney for personal care, and that person would be the substitute decision maker within the scope of the power of attorney. So if it's for personal care and it has no conditions or restrictions, then that person would be the substitute decision maker for treatment decisions and for other personal care decisions that are not treatment decisions.
Hmm. Okay, thank you. And just as a reminder for folks, this recording and any resources are going to get shared out with you. So as for those of us that are new to this and we're trying to figure it all out, we can rewatch and stop and process all this great information. And there's a lot of wonderful resources on ACE's website and others as well. Question two, which is sort of maybe a carryover from the last one. Can a substitute decision maker appoint a power of attorney?
No. Um, in our opinion, the law is clear. It's only the person whose rights are an issue who can make an appointment of an attorney for property or personal care. Somebody, if you're named as the attorney for property or personal care, you don't have the legal right to appoint a substitute attorney.
Okay. So you can't make those kinds of decisions for your person. You can only make the decisions for their property or personal care. You can't pass it on.
There's
Those
that
need to be
you can't pass it on. The person who's
right.
giving the power of attorney could give multiple attorneys. They could name joint attorneys, or they
Mhm.
could give alternate attorneys. They could, for example, say, uh, my daughter. I name my daughter as my attorney for property, and if she's not able or not willing to act, then I appoint my son or my granddaughter. And so the person giving the power of attorney can name alternates who would step in for each other. But that's not something that the attorney themselves can do because there are some types of decisions that can't be made by an attorney. One of those decisions, for example, is getting married. That's a legal act, but it's not a personal care decision and it's not a property decision. Something I'll be presenting on shortly in another session is capacity for intimacy, for sexual relations, or so on. An attorney has no authority to give or refuse consent to that type of decision.
That's a very interesting point and something that I don't think folks often think about, but sometimes we find ourselves in those scenarios where maybe we are decision makers for our loved ones, and those are the kinds of decisions we just can't control, right? So very, very interesting point.
I had a
A
client who
question.
once called his son his power of authority. Uh, and that's what it felt like to him, is that his son, who held his powers of attorney, was in charge of everything. But the there are people who believe, sometimes health practitioners believe, that we should take the word power out of the word power of attorney because it gives the person named as the attorney this idea that they're all powerful and in charge of everything, but they aren't. If it's a
Mm,
power of attorney for personal care, it only relates to personal care decisions, including treatment, admission to long-term care, and personal assistance services within a long-term care home. If it's for property, it only gives power over property decisions, not including things like visitors. If you're an attorney for property, you don't have the right to exclude or restrict visitors on behalf of an incapable person. So I'll stop there.
No, that's thank you. That's, I think, a very good clarifier and helpful for folks that are new in this space or maybe have been caregiving for quite a long time and have those sort of relationship frustrations. Or for those professionals on the call that maybe have clients that are in that space where does our reach extend to and where does it stop? And I think that's a really important clarifier. Can you speak to the relationship between the Mental Health Act and the Substitute Decision Makers Act, and I'll explain in relation to capacity and consent. So, for example, if there is a person who has dementia as a diagnosis, along with a severe mental health disorder, does the Mental Health Act take precedence? How does that work?
Well, it's actually a little more complicated than that because if it depends on what type of decision. If the decision is a treatment decision, then it's none of the above. Because if it's a treatment decision, we're dealing with the Healthcare Consent Act. And if the person is incapable of their treatment decision under the Healthcare Consent Act, then the hierarchy of substitute decision makers we discussed, starting with court-appointed guardian and ending up with the public guardian and trustee applies, and the principles of substitute decision making to follow the last capable wish that would apply in the circumstance, or if there is no last capable wish that would apply in the circumstance, to act in the person's best interest would be the cardinal rules to follow. And all of that is under the Healthcare Consent Act. The Mental Health Act and the Substitute Decisions Act have nothing to do with it. However, the Healthcare Consent Act has nothing to do with property decisions. And here, the Mental Health Act does have an important role to play. If a person is admitted to a psychiatric facility as a psychiatric patient, then upon admission, the patient must be examined by a physician as to their mental capacity to make their own property decisions. If the physician finds that the person is not mentally capable of making their own property decisions, then the physician will issue a certificate of incapacity and issue that to the public guardian trustee, who will then become the person's statutory guardian of property and can delegate that authority to a family member or a trust company who applies for it. When the person is discharged from the psychiatric facility, they must be again examined by a physician as to their mental capacity to make their own property decisions. If the physician finds that despite being discharged from the psychiatric facility, they're still mentally incapable of making their own property decisions, then the physician will issue a certificate of continuance and send that to the public guardian trustee, which means that the statutory guardianship already created will continue in effect, even though the person has been discharged. And if the physician does not issue a certificate of continuance, then the statutory guardianship will terminate when the person leaves a psychiatric facility. And so for these statutory guardianships we mentioned very briefly, there's actually two ways of creating them. The first way I mentioned, having a capacity assessment done by a designated capacity assessor, applies to everyone who's not a patient receiving psychiatric care in a psychiatric facility. For people who are psychiatric patients in psychiatric facilities, it will be decided under the Mental Health Act.
Complicated. Complicated. Thank you. Okay. I'm going to try, we're getting lots of questions coming in, so I'm going to try to bang through some of these quickly. We've got a couple questions through around wills. Where can we find help for a senior with low income to make a will? So I often get this question as well when I'm in the community. Folks that are on ODSP or Ontario Works, maybe they're just living off their pensions, whatever the case may be. They've never done any advanced care planning, looking at wills. And they ask about, do I download that thing off the internet, or do I need a lawyer to sign off on this? Do you have any tips or advice for folks that are in that lower income space and where they can find some resources or documents, or how they would go about preparing a will for themselves?
Well, I can give some tips. I can't give case-specific advice. The first thing is whether you should have a lawyer help you do your will. And that really depends on what your assets are. You know, if you're someone who, say, has a low income, but you own a mortgage-free house that's worth $300,000, $500,000 or more, then it really would be in your interest to have a lawyer draw your will because, if something went with your house, if your house needed a new roof, you'd say, well, I really need to spend my money to get a new roof. And so too, if you have an important, valuable asset and you're trying to make sure that it's transmitted among your estate as you wish, it would be important to get legal advice to do that. It's really an incident of the cost of ownership. If you have on the other end of this spectrum, if you have very little money and really no assets to speak of, someone, let's say, who receives the Canada Pension Retirement Benefit, the Old Age Security Plan pension, and the Guaranteed Income Supplement, and really has little to no savings, say under $5,000 or something in that neighborhood, and they want a will, really what you're looking at is most importantly, appointing your personal representative who's going to administer your estate for you. And secondly, distributing your estate, which is very small. And in that case, it may be available to the person to do their own will in terms of a holograph will, which is a will made all in writing, in your own handwriting, not on any printed form. And it doesn't have to be witnessed. It should be dated. And there's information on the ACE website. We'll distribute some resources afterwards as to how you might do your own holograph will. In the mushy middle, if you're not dealing with a $500,000 estate, you're not dealing with a $5,000 estate, it's not all that easy to come across free legal resources for doing wills. We at the Advocacy Centre for the Elderly generally don't do them because if we did wills, we'd be doing nothing but that, and we wouldn't have the staff resources to do other things. Some legal clinics throughout Ontario do wills, and so if you're low income and you would qualify for legal aid services, you may contact your local legal aid clinic, and your local clinic might be able to assist you with a will. And other than that, I'm not really aware of places people can go to get wills done free of charge. But really, I think it's important that if you do have an estate to distribute, that you not go cheap on getting a will done, because a will that is not clear and not legally binding can cause a lot of grief and dissension among your potential beneficiaries after you're gone.
And just a follow up to that, there was a question around international assets versus Canadian assets. Can you speak to whether that's all encompassed in the will? Like, are all of these assets included, or are there other considerations for things outside of Canada?
There are other considerations, and
Okay.
if I can pause here to say, if you are someone who owns a condo in Florida or real property outside of Canada, then you should absolutely be getting legal advice on making your will. This is not where you should be doing it yourself. If I needed to put a new roof on my house, I might have a general idea of how to do it and think I know what I'm doing. And if I get up there and I make a mistake, my roof might fall in. Right? It'd be better that I get someone who knows what they're doing to build my roof. And if you have international assets, get legal advice. The general answer to the question is that a will drawn in Ontario will cover all of your um, movable property located anywhere in the world and all of your immovable property located in Ontario, but it will not usually cover immovable property located outside Ontario. So you may need a will to cover your Ontario property and a will to cover your Florida property. And that's as far as I can go. I'm not giving individual advice to anyone other than to say, if you have international property, get legal advice.
Great suggestion. Thank you. On the other end of that spectrum, say folks have significant amounts of debt, um, and they don't have a will. Nothing's been prepared. We've just sort of been struck with the sudden illness. There's a lot of debt we're carrying in. What happens to that debt after that person passes away? Is that then go to the substitute decision maker for responsibility? How does that play out?
A situation where a person has a lot of debt Here, I'm going to make it more complicated and assume that they also have a lot of assets. Because if the person has no assets and a whole lot of debt, then it may be just the case that the creditors are straight out of luck because it becomes an unadministered estate. The purpose of administering an estate is to deal with the assets. And if there's no assets and only debt, then there's no estate to administer. But if the person dies with significant assets and significant debt and they don't have a will, then a few things can happen. One is if there is someone interested in the estate who wishes to do this, they could apply to the Superior Court for a certificate of appointment of an estate trustee without a will. So this was what's called an intestate estate. A estate where someone has a will is called a testate state, Testate. And a estate where someone doesn't have a will is called an intestate, Intestate estate, meaning without a will. And even if there's no will, someone can make what used to be called an application for probate, or now appointment for a certificate of appointment of estate trustee, and the estate trustee would then be responsible for administering the estate. If there's no one stepping forward and there are assets, then the Office of the Public Guardian and Trustee might administer the estate as well, which really is a last resort.
Thank you.
Oh,
Thank you.
sorry, I forgot the
Please.
important thing, Katie. The question was, what does a substitute decision maker do? And the answer is absolutely nothing, because the moment the person draws their last breath is when the power of attorney for property expires as well. And there is no substitute decision maker after someone dies, I'm sorry to say.
Yes, no, thank you. Thank you for that, Graham. We are at our time. We had a few more questions. Unfortunately, we didn't get to those today, but again, folks, we can watch the recording. Lots of resources that we're going to be sharing with folks. I want to thank you again, Graham, for joining us today. Your knowledge is so helpful to us as newbies and folks that are navigating this caregiving experience. So we're so grateful for your time and your expertise. Thank you to all of you for taking time to join us today.